You're watching a legal drama, and the defense attorney dramatically jumps up with hearsay. What really is hearsay? Let's talk about the hearsay rule. I'm Jim Crayveld, founding and lead attorney at Crayveld Family Law. And hearsay is a really challenging subject. You spend a whole semester on it in law school. It's an out-of-court statement offered to prove the truth of the matter asserted, which means the statement being made is to prove that it's true. So if a witness says, well, my friend told me that she saw the driver driving drunk, that's hearsay, because you can't cross-examine the friend who's not there in court. Because you can't just simply rely on a statement that someone may be making up, because you can't say, well, how do you know they were drunk? How do you know they were driving? What were they driving? And again, with cross-examination, you can try to make sure that the statement is reliable. Probably an additional objection, you have no business proving that someone is drunk. But say, I saw the man walking across the road in blue clothes. You can then cross-examine them. So when someone is saying so-and-so said to me, it's a problem. A lot of parents end up in court and they say, but my kids said this is what they experienced at the other parent's house. No, it's hearsay because the kids aren't there to be cross-examined. So if you're representing yourself and you want to get that information into the court, you're not going to know how to do it. I see a lot of people, if they're unrepresented, they show up into court, they have letters of reference, and every single one of those statements is hearsay because you can't cross-examine the witnesses. So if you're going to show up and try to represent yourself and you don't know the hearsay rules on how to get it in, that's going to be a problem. The hearsay rule, by the way, has over 30 exceptions to the rule where you can get the out-of-court statement admitted as evidence for the judge to consider at your trial or at your evidentiary hearing. But you need to know those rules. The rules in Michigan, they're technical, they're unforgiving, they're decisive. I've seen cases where I've been in a hearing, the opposing counsel didn't know the rules. I object, they get frustrated because they can't prove their case. That's not my problem, that's not my client's problem, but that is their problem. Yes, it's one of those challenging courses that we had to take in law school. But even then, very few law students got A's in the rules of evidence and dealing with hearsay. So you need to know that when you hire an attorney, ask them, have you tried cases? Have you gone to evidentiary hearings? So that they do know how to deal with the rules of evidence, including the hearsay objection.